Madam Secretary, please begin.
Good morning. This is the City Planning Commission public meeting held in Spector Hall, 22 Reade Street. Today is Wednesday, September 17, 2014. As a courtesy during the proceedings, we ask that you please turn off all cell phones and beepers. All speakers should fill out a speaker's card at the desk outside of Spector Hall. In addition, we ask that those providing testimony please identify yourself, limit your remarks to 3 minutes, and speak clearly into the microphone. I will now call the roll. Chairman Weisbrod.
Here.
Vice Chair Knuckles. Commissioner Besser.
Here.
Commissioner Cantor. Here. Commissioner Cerullo.
Here.
Commissioner Delauss.
Here.
Commissioner Dweck. Commissioner Edie.
Here.
Commissioner Efron.
Here.
Commissioner Jung.
Here.
Commissioner Levin.
Here.
Commissioner Marin.
Here.
Commissioner Ortiz.
Here.
A quorum is present. The first item is the approval of the minutes of the regular meeting of Wednesday, September 3rd, 2014.
On the minutes, a motion to approve the minutes. All in favor, please so indicate by saying aye.
Aye.
Anyone opposed? The minutes are approved, Madam Secretary.
The next part of the calendar is the report section on page 1. Borough of Brooklyn, calendar number 1, CD4 N150068 HKK, in the matter of a communication regarding the landmark designation of the Ridgewood Lodge 710, on the adoption of calendar number 1 for referral to the City Council. Chairman Weisbrod.
Aye.
Vice Chair Knuckles. I'm sorry. Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Cerullo.
Yes.
Commissioner Delauss.
Yes.
Commissioner Edie.
Yes.
Commissioner Efron.
Yes.
Commissioner Jung.
Yes.
Commissioner Levin.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Calendar number 1 has been adopted. Borough of Staten Island, calendar numbers 2 through 4. Calendar number 2, CD3, C140210ZSR. Calendar number 3, N140211RAR. Calendar number 4, N140212RAR. In the matter of applications for the grant of a special permit and for the grant of authorizations concerning the Gateway Cathedral. For a favorable report on calendar number 2 and for adoption on calendar numbers 3 and 4. Chairman Weisbrod.
Aye.
Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Cerullo.
Yes.
Commissioner Delauss.
Yes.
Commissioner Edie.
Yes.
Commissioner Efron.
Yes.
Commissioner Jung.
Yes.
Commissioner Levin.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Abstain.
A favorable report has been adopted on calendar number 1, and calendar numbers 3 and 4 have been adopted. Borough of Staten Island, calendar number 5, CD3, N150047 RCR, in the matter of an application for the grant of a certification concerning 88 Holcomb Avenue, for adoption on calendar number 5. Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Cerullo.
Yes.
Commissioner Delauss.
Yes.
Commissioner Edie.
Yes.
Commissioner Efron.
Yes.
Commissioner Jung.
Yes.
Commissioner Levin.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Calendar number 5 has been adopted. Borough of Staten Island, calendar number 6, CD3, N150066 RCR, in the matter of an application for the grant of a certification concerning 117 Madison Avenue, for adoption on calendar number 6. Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Cerullo.
Yes.
Commissioner Delauss.
Yep.
Commissioner Edie.
Yes.
Commissioner Efron.
Yes.
Commissioner Jung.
Yes.
Commissioner Levin. Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Calendar number 6 has been adopted. The next part of the calendar is the public hearing section on page 4. Borough of Manhattan, calendar number 7, CD4, N140410ZRM, a public hearing in the matter of an application for an amendment of the zoning resolution concerning the auto showroom text amendment.
The first speaker is Zach Bernstein. Mr. Bernstein, a pleasure to have you here.
Chair Weisbrod and Commissioners, it's a pleasure to be here. Commissioner Cantor, happy birthday. I knew that, just trying to be nice. I'm Zachary Bernstein with the law firm Reade, Frank, Harris, Schreiber, and Jacobson. We're representing 605 West 42nd Street Owner LLC, an affiliate of the Moynihan Group, and the applicant for a text amendment to allow vehicle service, preparation, and repair uses in conjunction with an as-of-right automobile dealership use within the 42nd Street perimeter area of the Special Clinton District. The site is located, and the text amendment applies west of 11th Avenue between 42nd and 43rd Street. To the north of the site is an M24 district, and directly to the north of this site is a large UPS depot facility. 2 blocks south of the site is also a manufacturing district, and the project area is located within an area of the city commonly referred to as Automobile Row, and the heart of a thriving industry of automobile dealership and service uses. The proposed development is a mixed-use development containing predominantly residential use, including 235 affordable units. The development also would contain a health club approved by the BSA. The development will contain retail uses located at the northwest corner of 42nd Street and 11th Avenue. This is a view from the south looking northwest at the building. The project will contain a driveway to take vehicles off the street for residential drop-offs along 42nd Street. And I will just flip these boards to show the site plan for the property. As noted, the north side of the building is adjacent to a manufacturing district and across from a UPS facility, and this is a particularly large site with approximately 50,000 square feet of cellar space. And in looking at potential uses for this space, the applicant identified the strong automobile industry in the area and a positive location for this. And in this area, automobile dealerships are allowed as of right as a use group 9 use, but the associated service and repair uses are not allowed. There are other texts within the Special Clinton District that allow for this, so this text is tailored to allow within the special use regulations of the 42nd Street perimeter area service and repair uses. So, I'm available for any questions and to further describe the operation of the site or to discuss the community board and borough president's recommendations on the project.
Thank you, Mr. Bernstein. Any questions for Mr. Bernstein? Ms. Delaus.
Hi, thanks for being here. I just want to confirm something from the community board's recommendation specific to amending 9621 of the special regulations. Basically, your recommendation to allow the service use versus the community board's recommendation in terms of how to accommodate that exact same use, and whether or not you are fine with their approach to achieving the same goal.
Thank you. Yes, the community board voted 34 in favor with 1 abstention to recommend approval of this with 4 conditions. Those conditions were all related to quality of life for the neighborhood in connection with the dealership, and the applicant has committed positively in response to all of those conditions. Would you like me to discuss those conditions?
We have them here.
Okay.
Thank you.
Ms. Levin.
Well, I guess I would like to follow up on one of those conditions, and that is about the lighting, which is, I think, particularly sensitive across the street to the east, where there's a residential building. Not so much a problem to the north, because that's the UPS facility, and what do they care about lights?
Right.
So could you tell us what the lighting plan is? Your letter says that lighting will be designed, your letter to the community board says that lighting will be designed so as to minimize glare into surrounding dwelling units and to minimize motion or flashing, but does that mean there will still be some glare and some flashing?
Well, there will be signage at the development. The site is here. Actually, directly across the street is not the residential component of this building, and so the signage for this facility will not be directly across from the main residential tower to the east.
Right.
But there isn't there isn't a finalized agreement with the operator, and so there isn't a signage plan yet. That will be developed with the operator, but the applicant has committed in the lease with that operator to have specific restrictions so that there will not be negative effects of lights essentially flashing up into the residences to the east, to the south, or the north.
Okay, do they anticipate using animated flashing lights, or will it be more like the kind of signage we see along 11th Avenue?
The
now?
signage has not been designed yet,
Okay.
and so we've committed to restricting in the lease and to working with the operator to, we're going to have to continue to work with the community board, and we have residents in our own building. The applicant owns the development site to the north and the east, so there's a strong interest in making sure that there's not a negative effect on the neighborhood.
Okay, good. And then could I just confirm some information that we got as a result of a question that I had at certification, and that has to do with the accessory parking, which is not part of this application, of course, but now's my chance to ask about it.
Go for it.
I know you have it planned for, is it the mezzanine and the second floor, and I wanted to confirm that it is below 23 feet and that it will be wrapped so that
That's
we're not
correct.
looking at cars from
Yeah.
the outside of the building.
Yes, all the parking will be below 23 feet and is as such exempt from the floor area, and all of the parking will be wrapped in accordance with the Special Clinton District regulations.
Excellent, thank you.
Sure, thank you.
Mr. Cantor.
Good morning again. To further on Ms. Levin's question, are you contemplating or is it off the table with respect to moving signage?
A signage plan has not been established for the dealership.
You've made that clear.
Right. The signage would follow applicable zoning regulations. It's something we can follow up on after this meeting, if you'd like.
That would be appreciated, thank
Okay.
you.
Ms. Efron.
Since you mentioned that the applicant has other properties in the area, and there does seem to be an increase in the number of repair shops in connection with these showrooms, I just wanted to say how exciting it was that manufacturing is actually coming back in that neighborhood, and hope that those will all be coordinated in such a way as to benefit those who are really trying to work up the work ladder. But my question is about the UPS site, since there's been some mitigation of exhaust matters that seems to be facing the UPS, and I don't know if you know the answer. Does UPS own the site, or does it have a long-term lease, or is this something that in 5 years will be a new issue?
My understanding is that UPS owns the site. Commissioner Levin knows the area very well and is nodding in agreement.
Thank you.
Sure.
Any other questions for Mr. Bernstein? Or perhaps Commissioner Levin would like to answer the question. Thank you, Mr. Bernstein.
Thank you very much.
Bashi Gerhardt's from the Manhattan Borough President's Office.
Good morning, Chair Weisbrod and Commissioners. Happy birthday, Commissioner Cantor, and we also wanted to say congrats to Commissioner Levin for her reappointment. Very excited. I am Basha Gerhardt, Deputy Director of Land Use, here on behalf of Manhattan Borough President Gail Brewer in support of the application by 605 West 42nd Street owner LLC for an amendment to Section 9621 of the zoning resolution to allow automobile servicing, repair, and preparation of automobiles for delivery within a portion of Subarea 1 of the 42nd Street perimeter area of the Special Clinton District. This text amendment will allow for a full-service automobile dealership use that is proposed as part of the development of a 60-story mixed-use building. The building will contain approximately 1,174 residential units, of which 235 will be affordable for households earning less than 60% of the area median income. The affordable units are being built through the city's inclusionary housing program. There will also be an accessory parking garage with 301 spaces. At its full board meeting on July 23, 2014, Manhattan Community Board 4 voted unanimously with 1 abstention in favor of a letter recommending approval of the proposed action with conditions. The board noted that the proposed use is appropriate for the area. The board also requested a change to the location of the proposed zoning text and for 4 quality of life provisions to be included in any future lease. In a letter to Community Board 4 dated July 22nd, the applicant committed to these quality of life provisions. A pledge was also requested by our office to further restrict new car delivery between the hours of 11 p.m. and 6 a.m. The applicant sent a letter dated September 9th to the Borough President restating their commitments to the board and agreeing to the proposed hours. The Community Board's recommendations regarding placement of the proposed text seek to make the zoning text for the Special Clinton District as clear and concise as possible. This is an important goal. Codes that are not repetitive or redundant or more easily understood and leave less room for error from city agencies, property owners, and community groups. The goal of the Community Board should be taken into consideration by the City Planning Commission. However, in this case, amending Section 9634B1 to include the 42nd Street perimeter area may not serve the purpose of clarity, as one would not instinctually think to look in the special regulations in Northern Subarea C1 to find rules for the 42nd Street area. To achieve the goals of the Community Board, it may be more appropriate for City Planning to consider reorganizing as a corrective text action all special rules for accessory automotive uses in one subsection, since these same rules now apply to multiple sub-districts. Considering the commitments from the applicant to mitigate the harmful impacts of this use on the community, this project will be beneficial. Full-service dealerships not only provide additional services, they employ significantly more people. These additional jobs in the neighborhood help support other daytime uses and help to create a diverse community. I urge the City Planning Commission to approve this application with the above referenced reorganization of the zoning text.
Thank you, Ms. Gerhardt's questions. Will you submit that in writing to us, that your statement?
Yes, of course.
Thank you. And I assume by all other areas, you mean all other areas in the Clinton Special District?
Not the other areas as defined sub-district, but multiple.
Not the so-called tribal
exactly.
other area?
Right, there's multiple sub-districts now within Special Clinton, within the Special Clinton District that now have very similar provisions, and we thought it would make more sense to just pull all of these very similar provisions into one subsection. So if someone wanted to see what they could do for an automotive use, it would just be in that, and it would say something to the effect of these provisions apply in the following sub-districts, and then list, especially since it seems like other projects may be coming in through the pipeline that may want a similar provision. That'll also make it easier on everyone to amend the text as well.
Thank you. Any questions? Thank you, Ms. Gerhardt. Is there anyone else who wishes to be heard on this matter? If not, the hearing is closed.
Borough of Manhattan, calendar number 8, CD2, C140114, ZSM. A public hearing in the matter of an application for the grant of a special permit concerning 37 Great Jones Street.
First speaker is Richard Lobel.
Good morning, Chair, Commissioners. Happy birthday, Commissioner Cantor. Richard Lobel of Sheldon Lobel PC for the applicant. In my allotted time, I just was going to give a brief background regarding the application and be happy to answer any specific questions. The application in question is 37 Great Jones Street, which is a rather small lot, about 26 feet between Lafayette and Bowery. The property is located in an M15B district, which does not permit residential use as of right, and which does not permit retail use below the floor level of the second story. So the owner here has a building which is a longstanding building built in 1917 to 1918, and so wished to avail himself of the special permit process pursuant to 74-711. That special permit, upon certification of a report by the Landmarks Preservation Commission, and upon agreement by the owner to enter into a continuing maintenance agreement for the caretaking of the building in perpetuity, allows the CPC to waive use and bulk requirements with the exception of floor area for the use of the building going forward. And so here, the applicant has so applied for a use waiver for the ground floor, which would waive 4200 and would permit, or actually 14D2B, which would permit the commercial on the ground floor, and 4200 to permit the residential above. As far as the history of the applicant was before Landmarks between 2012 and 2013. In 2013, Landmarks issued a report, January 31st, 2013, discussing the building and the fact that the issuance of the special permit by the Commission would indeed fulfill the goals of the NoHo Historic District Extension, specifically stating that the work would, quote, return the building closer to its original appearance, that the exterior facade work will reinforce the architectural and historic character of the building, the streetscape, and the NoHo Historic District, and that the restorative work will bring the building up to a sound, first-class condition and aid in its long-term preservation. It's really rather an attractive building. The owner, prior to receipt of any assurances of a special permit, engaged in the work at the building. It was extensive. There was, in addition to the facade work, there was extensive internal work, remediation, removal of a decayed boiler, flooring, windows, cracked windows, and extensive asbestos remediation. He accomplished this work. He received his certificate of appropriateness from LPC and essentially built the building or reconstructed the building and added a 6-story penthouse as per LPC approval and the certificate of appropriateness. Which is why we're in front of the commission today. We basically, relying on the report of the Landmarks Preservation Commission, seek the commission's approval of the application and would rely on the satisfaction of the findings as set forth by LPC as far as the A finding, and in the B finding, really feel that this is within the character of the area given the uses of the residential and commercial buildings around this building. I see that my time is up, and I would be happy to answer any specific questions with regards to the application.
Questions for Mr. Lobel? Ms. Levin? Well, Mr. Cantor,
Okay, ladies
it's your birthday.
Richard, did Landmarks also agree to a change in use on the street floor?
They did. The Landmarks certificate contemplates the city planning application, so they understood that we would be going through the process in order to obtain commercial on the ground floor and residential above.
And could you tell us how we got from past the paperwork and indeed took occupancy without an approval?
Sure. The approvals allowed the physical construction of this building and the improvements to this building. And there was a TCO that was received on the building on July 24th. That TCO, pursuant to the legal permits issued by DOB, allowed the ground floor to be an artist studio, and the second floor with JLWQA above. So at the time, Roger Dibb, who is the owner, didn't have a thorough understanding of the fact that he needed to have certified artists occupying the building. So in June, prior to the issuance of the TCO, he did enter into a lease for the ground floor space and for the second floor space for both a commercial tenant and for a residential tenant above. At the time of the community board hearing, he understood after that time that he was not permitted to proceed with residential tenants in the building prior to receipt of the special permit. He therefore cut off any negotiations for the third, fourth, and fifth floor, which have remained vacant since that time. I've spoken to Roger about this. I've spoken to the second floor tenant about this. Roger was deeply ashamed about the fact that was not aware of this. He said that he would reach out, and if there was any application which needed to be made for artist certification for the second story tenant, he would do so. We spoke to an attorney about that. The truth is that there was an understanding at the community board that there was this tenancy in the building, but that moving forward, he would not be able to tenant the building. And so the community board conditioned its recommendations on that. The reason that this was out there at the community board and it was thoroughly discussed was because there were residents there, people from the neighborhood who were keeping a close watch on this building, including the NoHo Bowery Stakeholders Association. Zella Jones, who is the president and represents more than 350 members in direct proximity to this site, was in attendance at the community board hearing, did issue a letter, which I believe was circulated to the commissioners, and really talked about the fact that as far as owners go, Roger is a good guy. He basically, as per Zella's letter, he engaged in, quote, extensive and costly remediation of environmental hazards. His sensitive modification to its design and historic character has transformed this building and its use to an admired and contextual addition to our community, even to the leasing of the ground floor space to a revered local designer moved from the Lower East Side, whose aesthetic fits perfectly with the ground floor galleries and upper floor design. So my feeling about this, because obviously I come to the commission with a range of clients, my feeling is that Roger, out of his own pocket and without any assurance that he would ever get this approval, spent more than $2.5 million in the remediation, costly remediation of this building, went forward with the tenancy. Once he understood that that was incorrect, completely stopped that and is now waiting for the rest of the process.
When he got the TCO, did the TCO allow for the use group 6?
It did not. It allowed for use groups 9 and 17. I think that Roger's understanding at the time was that the ground floor is, the name of the company is Deere Rivington, and they are a local designer, as was stated by Ms. Jones in the letter she submitted. And while they engage in some manufacturing on the site in the form of designing and creating clothing as well as pottery, they're not technically a use group 9. So they are. It's the balance of it would be a retail use with a manufacturing component. So Roger, I think that he really wanted to comply. I think the local area, as evidenced by this letter, loves this designer being here, but technically, no, it's permitted for use group 9.
Ms. Levin.
Yeah, Mr. Lobel, it seems pretty clear to me, and I suspect to my colleagues, that the technical requirements of the special permit have been amply met, and it's great that this building has been fixed up and returned to productive use. But the sort of procedural aspects of this application are really troubling. It's hard to understand. I mean, these issues are so heavily regulated. How can you get through the Landmarks Preservation Commission understanding that a special permit is going to be required and still arrive at a situation that you've just candidly described? And I have to say, I certainly appreciate your candor.
Right.
You seem to specialize in these tricky situations.
I hate that.
And if I were in that kind of situation, you're the guy I'd want to hire, because
That I appreciate.
you have a record of honesty and candor with us that serves your clients very well. How long have you represented this guy?
We've represented him since 2013.
So did you handle the application at the LPC?
We did not.
How can it be that these tenants were allowed to occupy the building in the middle of the special permit application? What's the point of applying for a special permit if you're just going to go ahead and fill the place up?
I think that, sadly, the city of New York is filled with bad actors who are flouting the law and are purposely evading the process. I don't think Roger is one of those people. I think Roger sought out, wanted to make this building kosher, for want of a better term. If you look at the dates that are involved here, the leases that he drafted and signed with the tenants were on May 28th and June 1st, 2014. The occupancies started in July 2014. So first of all, he wasn't going to have anyone in this building without a TCO. One hallmark, I would say. The next thing is that we attended the community board meeting, and at that point, Roger understood, okay, I don't have certified artists and a certified, a use group 9 here. I have an artistic designer who has a store and an artistic person on the second story, and immediately ceased tenancy for the remaining, did not sign a lease for the remaining space in the building. I understand, and I think that if you look at the timeframes here, this is not someone who for years and years has been essentially operating illegally. This is someone who, during the process, without a full understanding, essentially people started living in this building, and the lease occupants began in July 2014, and he, upon these community board hearings in July 2014, he stopped. And I think that I think that the commission, understandably, I think that he does meet the findings. I think that the commission has, weighs these things and looks at applications, and there's certain times where a legalization is appropriate. I mean, I had a personal case where in 2011, I represented a landowner in Brooklyn. It was March 2nd, 2011, C100-232-ZMK. It was a rezoning. It was for the Kingswood Mall. There was a rezoning that was accomplished from an R5B to a C44A in order to remediate, in order to correct an architectural error where somebody built 10 feet too far into the rear yard. This was accomplished over the objection of the community board. I came and I represented an adjacent owner, and I said, this really is not the appropriate action. I've got adjacent owners here who were next to 2-story residential buildings and now maybe next to 4-story commercial office buildings. And the commission felt that despite that it was a legalization and a guy, for want of a better term, messed up, that it was an appropriate exercise of discretion in order to fix that. And here, I think that we have someone who, who is not a long-standing bad guy, who has not built a three-story building in an area where he is not permitted. I would ask the commission to use its discretion and find this guy is okay.
Did your firm represent him in the lease negotiations?
We did not.
Ms. Delos.
Again, I appreciate the candor and the background on the other situation where discretion was exercised. I'm just wondering, how would you approach a similar situation with a different, or even the same owner in the future to help them understand the unique nature and the importance of completing the full process?
I think that from the applications we've done, and more importantly, from the litigation we've handled on people who have been found to be violating the law, I would say that I would engage in thorough conversations with them at the beginning of the process. I think when Roger and I spoke that night after the community board meeting, I said to him, I'm an attorney, I'm your attorney. I would never advise you to perform any illegality. And I also am not the business person here, but I would not, if I were you, touch those top 3 floors without appropriate approvals. And he took that to heart. To the extent that I can engage in those conversations early, I engage in them early. To the extent that a client will listen to me, I think that that's great, and I encourage that. I also think that, without wanting to overstate it, that the City Planning Commission is the commission, and the Department of Buildings is the Department of Buildings, and so should people get violations for their actions, that there are specific agencies which issue a violation and say occupancy contrary to certificate of occupancy. I would not wish that upon anyone, but that's a violation which is issued in the city every day. So I think that's kind of where I would stand.
Ms. Efron.
Is Roger, I'm sorry, just forgotten his last name.
Dibb.
Dibb, thank you. Is he a regular real estate developer in New York City?
He's a regular developer. He develops a number of properties. He was at the community board hearing. He had a full conversation with them. They discussed the fact, is this, what are your interests in the building? Roger discussed the extensive remediation. They asked him, are you condoing this building? He said, no, this is somebody who stays in the community, rents out to local people, keeps the rents so that, local people can live within the building. I spoke with the second-story tenant today, just to kind of touch base with her. She said to me that Roger has been nothing but a gentleman to her, and that, we talked about the fact that if she needed to, would she enter into a certification process as an artist? She said she'd be happy to do that. I think that, the timing kind of got in the way here, but I really don't think Roger kind of entered into this to say, I'm going to get an extra month's rent. I don't think that that's what this was about.
Thanks.
Mr. Lobel, I'm also deeply troubled by this. It seems like both a flagrant and, frankly, foolish sort of disregard of the city process. I have a number of questions about it. You were representing the developer owner at the community board?
Correct.
And did he seek your guidance about whether he should enter into these leases?
He didn't. I think as far as Roger was concerned, he, through separate counsel, negotiated and drafted a lease in May and June 2014. And I honestly think, having talked to him about this a lot, was that he understood that the lower floor tenant he thought that they were an artist, and he thought that the second story tenant, who I've spoken to and basically runs an online magazine. It's a design and fitness magazine. She consults with Lululemon and Estee Lauder, so it's an artistically inclined business. I think he thought he was doing correctly by this.
My understanding, correct me if I'm wrong about this, but my understanding is that at the community board was aware of the ground floor tenant, but unaware of the second floor tenant. Is that correct?
I know that they basically discussed the residential tenancies, and I know that he discussed the fact that the third and fifth floor, through fifth floor, were unoccupied, but that there were the people who had active leases, for execution. The second floor, I can't honestly say whether or not. I think that we disclosed that to the community board, and I know the community board said to us, you know, and conditioned their resolutions and said, we don't want any, we don't want occupancies prior to the time of the special permit. But I think the discussion at the community board was as a technical matter, should they engage, should the tenants at that point, and then there was prospectively 4 and now there's 1, should they engage in the certification process, it was likely that that certification process would exceed the time period required for the grant of the special permit. Again, I just don't think that he was purposely flouting the law.
The second floor applicant, the second floor occupant was already in occupancy at the time of the borough president's review of this?
Had an executed lease and was in occupancy at the time of the borough president because
Was the borough president's office aware of the occupancy?
I had a conversation with the borough president's office. I went up, we talked about the building. I mean, I think that there's a discussion as far as they're concerned, and they say that we misrepresented this. I don't think we misrepresented this for the sole fact that there was, if we hadn't tenanted the building and there was a discussion at the community board, this would never have come up. We would have never have said, you know, that they would never have said we're not in favor of putting people in this building before the issuance of the special permit.
Just to follow up on Commissioner Efron's question, this is not a naive developer.
He's not, but I think in this area and as far as this approval process, he was.
Has he developed other properties in Soho?
He has not developed any other properties that would rely on the special permit. That basically were not, where he was unable to get.
Were all of his previous developments as of right, or
I'll have to check on. My understanding is that they have been.
Thank you.
Sure.
Basha Gerhardt.
Good morning again.
Good morning.
A little different tone for this one. Given the new conditions Joel presented on Monday regarding the lease and occupation of the second floor after the community board hearing, I am here to amend the borough president's recommendation and will read Gail's letter to the chair and to the public record, which I also submitted to the secretary. Dear Chair Weisbrod, I write in regard to the application by DIB Management, the applicant, for a special permit pursuant to Section 74-711 of the zoning resolution to modify use regulations in accordance with zoning resolution Section 4214 D2B to allow use group 6 retail uses on portions of the ground floor and cellar, and with zoning resolution Section 4200 to allow use group 2 residential uses on the 2nd through 6th floors, with accessory residential uses on portions of the ground floor and cellar of an existing 6-story building located at 37 Great Jones Street. I submitted a recommendation for approval dated September 8, 2014 to the Department of City Planning as part of the ULURP process. I was dismayed to learn this Monday from the Department of City Planning that the second floor of the subject property has been rented for residential use, which is not permitted as of right. If this is the case, my recommendation was based on information that has now been rendered inaccurate by deliberate subsequent action of the applicant prior to the completion of ULURP. Even though the subject application would allow for the use to conform in the future, the public process is not complete. It is also a serious concern that the residential use was not analyzed as part of the EAS as an existing, as in pre-approval, non-conforming use. My approval was granted with the implicit understanding that no owner would so blatantly and completely disregard the public process in which they were currently engaged. We have to uphold the integrity of the ULURP process. Someone cannot circumvent ULURP by deciding to assume approval before it is granted. Therefore, I respectfully request that you and the City Planning Commission consider disapproval of this application. The current facts and behavior of the applicant have affected my ability to rely on their stated commitments, and I no longer recommend approval of the application. Sincerely, Gail A. Brewer.
Questions? Ms. Gerhardt, I'm just informed by city planning staff that the penthouse of this building is currently listed for rent without any limitation on it for joint living and work quarters for artists. Are you aware of that?
No. I would also like to add, if the resident of the second floor is eligible to be a certified artist, that would also have fallen into our consideration for the conversion of use to residential, as our standing should be that those kind of joint living work quarters should be preserved, and a certified artist should be allowed to remain, and we would not necessarily sign off on that conversion to residential.
Just in terms of your discussions with the applicant at your review of this, or Borough President's review of this, was any inquiry made regarding the occupancy of the second floor and above at that time?
It was our understanding, and again, I was not physically present for these discussions, but I trust my division and the borough president's recollection of these conversations, that the second floor was only brought up in the sense of the community board recommendation saying that the second floor should not be occupied for residential use. So we didn't really look into it because we thought, oh, no one would actually go ahead and occupy the second floor with a residential use when they're in the middle of the ULURP process to allow that to be residential use. And that would be a violation. So DOB would, issue a fine and a violation. And again, no one would actually go ahead and do that. So we didn't even think to point it out again, since the community board had already pointed it out. It was our understanding that even if leases had been put out there into the universe, that again, no one would be allowed to execute it and allow someone to move into their building when they're in the middle of this public process.
Thank you. And I just want to know for the record, I would have asked Mr. Lobel whether he was aware that the penthouse is currently being listed for rent, but I was unaware of it when he was testifying. So, thank you. Any questions for Ms. Gerhardt? Do you, what? Thank you, Ms. Gerhardt.
Okay,
Mr. Lobel, would you like to come back and respond to my question to Ms. Gerhardt?
Sorry, is the question whether or not I was aware that the penthouse was being listed for rent for JLWQA purposes?
Currently, yes.
For JLWQA?
No, for anything, not for general JLQ.
Was basically being listed for rent with no reservations.
That's my understanding.
Yeah, well, I think that there are leases right out that are out right now to potential tenants, which basically have been removed from consideration during the pendency of this action. So I think that basically that I think that there are residential tenants who are waiting to live here but are not living here during the pendency of this action. And again, I think that you have an applicant who spent $2.6 million to improve a building which required heavy remediation, and essentially went through this process since 2012. And so now there's kind of a judgment that's being weighed with regards to the last month.
I just find it surprising that after this has all come to light, after you've advised your client not to proceed to sign leases, he's still quite actively marketing space that has not yet been approved by us.
I think that if he had executed leases and there were people in these buildings and he had followed through on that, I think that would be indicative of something. But now I think that he probably just had this, and there's no bones about the fact that he had residential leases on the table for these different residents and has now said, these deals are off until I get approval.
Okay. Thank you. Any other questions? Anyone else who wishes to be heard in this matter? Hearing is closed.
Thank you.
Thank you. Madam Secretary, is there any other matter to be brought before us?
No, Chairman Weisbrod.
Then I will entertain a motion to adjourn. Adjourn. What?